Dear students, so welcome back to Property Law HOE 6011, and we have been looking at the laws with respect to neighbors and all the issues that can arise in this regard. So let's see, where are we placed? Well, 27th, so 28th when you see the lecture, and then we have maybe 5th, and then already 12th May, and then it's less than 4 weeks, and then we have the exams already. So I'll just talk a bit about certain things, and then of course wrap this up and then put up homework 5 soon as well, and then things should be okay. So how are the homeworks going? Well, let's see. Nemo dat principle 25th. Oh, done. Yeah, okay. So I'll start checking those homeworks and giving you feedback as well. And then there's homework 4, draft the will, and you have time till 8th May, so lots of time for that. All right, so we're looking at negative rights. Last time we looked at a bit of the different issues that can come up with servitudes and easements. So very often what you have with negative rights are restrictions and obligations, and these could be around all sorts of things. Very often you see this in the context of cities and urban development, because you have a lot of development going on and old houses are broken down and new houses are built, and this can often lead to a lot of, how would you say, conflicts with neighbors. So this issue is also looked at in the case of these case laws that I have put up in Moodle. So there's a Pryor versus Marity case, then the Anthony Stephen Davies versus Richard and others case, and all of these give rise to all sorts of issues that come up. There's also civil liability arising from an explosion, and then public nuisance issues. So lots of stuff over here to read and to understand. There's also an article about a statue on land, and again interesting because we will talk about this. All right, so there are a lot of these issues that can come up if you really want to upset your neighbors. There are a lot of ways for that, and a lot of these issues then end up in a court of law, which is very interesting from a legal viewpoint. So well, what are negative rights in this context? These could be, for example, as we saw in this case over here, there was this big piece of land, and then the developer, the company, made subplots and put up houses, and now you have this development that has taken place, and so suburban houses have come up now, single family homes or whatever, and so there could be some restrictions about what could be the color of your roof, or what style windows you can have, or what about satellite dishes or signs or things like that, and what sort of flags you can fly. So there's always scope for all sorts of negative and affirmative obligations. Now, although sometimes it could also be something different. So for example, this was something that came up a lot in 2009 2010, during the last economic crisis. The previous one. We are still in the new one now. So let's say, for example, the developer has done this, and now she or he has said that they will make houses, single family homes in a suburb. So 5 are done, and this is now left out. And now, well, the developer thinks, maybe there's more money if they were to set up something else over here, maybe a shop, or some industrial area, or maybe some striptease club or whatever. So now the question that comes up here is, can these other owners say no, you cannot do that? So that's where we have implications and implied issues that come up, and public policies and whatever could be discriminative or discriminatory or in restraint of trade. So all sorts of issues come up. So for example, maybe these are just plots, and so people over here have bought the plots and now they have built their houses, and the sixth guy here decides he doesn't want to build a house, but he wants to build a car repair shop. Now that may be upsetting for the others, because then you have cars parked here, you have cars all around on the roads, strangers are coming all the time, and then there is all this spare tires and oil changing and all sorts of things, and that could be considered as being very disturbing. So again, what's going on here is that although these people do not have any implicit legal right to insist that this also has to be a residential area and not a commercial area, there is a common scheme of things, and maybe in the development plan all of this was supposed to be residential. So you see, that's how all these conflicts very often arise, because in the setting, it's always so that 5 out of 6 plan to just have a family home and stay with their families, and there's always the sixth joker who decides that she or he wants to be different. So you often have a lot of these issues, and so that's spoken about in the implication aspect, which you can see in the notes. Then another interesting area is, of course, the right to light. And now, since we live in this part of Europe, we all understand how important sunshine is and why it can be such an emotional issue for lots of people. So now let's say here are 2 houses, okay, and there's a fence in between, and so this is a simple aspect about things. So here we are, 2 houses, there's a fence in between, neighbors. So this part is owned by A and this part is owned by B. Can't go wrong with that. Now what if B decides that Brexit has happened and now she cannot go to London anymore to have high tea or something like that, and how she misses Big Ben and all that. So she decides to construct a replica of the Big Ben. Just to remind her of pre-Brexit era life in the European Union. Okay, whatever. Well, now the issue here is, let's say the sun rises from the east, and that's been going on forever. So the person living here, A, could come and sit over here facing the east and have tea or coffee and enjoy the sunshine, the sunrise. But now that's not possible, because guess what? Big Ben is blocking the sunshine. Now, is this even relevant? How could this even be something of an issue? Well, you'll be surprised how this can come out, and I'll give you a real life example of this. So, well, in Tallinn, now I don't know how many of you remember Tallinn, and there is this Viru Keskus, and then behind, it's a sprawling area, and then behind them they have this giant statue of that naked lady, and then there are some other stuff, other stuff all around, and then there is this empty place at the back, where they have a car parking area, and the bus stop used to be called Kunsti Academia, and that was the whole region over there. And then now it's just a bus, just a car park, and it's a very empty piece of land, and it's a bit surprising what happened there. So it's a very interesting story. On that site was the Estonian art school or Academy of Arts, and this is where architects and everybody else, all artistic people went for training and things. So this was this Soviet era building. Some call it ugly, some call it concrete brutalism. Soviet Union had its pros and cons architecture wise. So there was this house. It was maybe I don't even remember, 5 or 8 floors high, and so that's how it was. All right, so basically, if I was to show it to you, well, let's say this is Viru Keskus side here, and more or less everything, and there is this statue over here of that naked lady, and then there is this over bridge, and then more Viru Keskus, yeah. So that's this thing. Yeah, that's the statue over here, and then there is this road which goes, and so you have all sorts of houses here everywhere, and here and here and here, and then if you go more ahead from here, I think you reach Sweat Bank and all sorts of places. Anyway, here is this giant empty place, and it's a car parking lot now, and this used to be Kunsti Academia, and so it was this house, and well, now the management of this institution got a European Union loan, and so the idea was that they will break down the old structure and build a giant 25-floor academy, which will have floors for all sorts of departments, and it'll be really nice and fancy. And being artistic people, they sort of said, okay, we have the piece of land, it's ours, we have the money. So they demolished the house, and then they applied for building permission. Yeah. And so the city government said, okay, well, this is the place, it's empty now, and it's just a formality, so we're going to have to ask if anybody has any objections to the building plan. And then some old woman here in one of these houses, she said, no, you cannot build this giant 25-floor skyscraper over here because it would obstruct her right to sunshine. And so people are like, what's wrong with you? What do you mean sunshine? When was the last time you had sunshine in Tallinn? That was like, you have 30 days of sunshine in a year anyway. But she said, no, this is my right to sunshine, and I always enjoyed the light, even when the old structure was there. And now you have demolished the old structure and you want to build a new one, and it's going to mean that I cannot enjoy my morning cup of coffee or whatever with the first rays of the sun. And it worked. Yeah. Sorry, but it's still a car parking plot because it sort of never took off. Now, of course, there are a lot of conspiracy theories and things, and some people believe that this was just a ruse to get this house out of the way. It's very expensive real estate, and it's been rebuilt in another part of the city now, and some developers want to make a 35-floor house here, and this woman is not saying anything anymore. But you see, this is what we refer to as right to light, and it can sometimes stop a multi-million euro project simply because somebody has an expectation about sunshine, and this is a seriously taken right. So, well, when we look at the right to light, I've given some examples here from the English law perspective, and so they have had this from the 1830s, and basically it deals with a scenario like this, for example. So if you have had access to light, and now a new construction is made in the neighborhood, and because of that your right to light is restricted, then you can apply for an injunction and stop the construction of a taller building or structure. And so this is quite interesting, and of course it's based on the English doctrine of ancient lights, and you can read more about it here. And remember the example I gave you, so it was the old Kunsti Academia, and well, you can't really miss it, because I think from here, if you go this side, then you reach Gonziori Park. Yeah, so that's over here. And I know, because a lot of Finnish students I used to see used to go here to some eat as much as you can buffet for 10 euros or something. And then of course there are some other facilities over here, and there's a park on this side and stuff. So this is the right to light. And of course, in the English common law perspective, what it states is that there is a particular time frame. So if you have had this right to light and you have enjoyed it for 20 years or more, then nobody can take away this right from you except with written consent or an agreement of some sort. And this also plays a role in the context of some other cases. There's this Pra versus Marity case, very interesting because you can read it, and of course what's happening here is that somebody built a house, and so a very integral part of this person's house was that they had this solar system, and so they had these solar lens and all those sort of things. It's very popular again nowadays, and then this was heating up this person's heating system and the boiler or whatever, yeah, different things. And now the neighbor decided to build a taller house or something, an extra extension, and got all the requisite permissions. Yeah, see, that's very important here. Got all the permissions, built a taller structure, and now because of that, the solar panels that are on the roof or whatever are now not able to get enough sunshine. And so this guy, of course, sues this person, but this person's defense is, hey, I don't know what you're so upset about because I took building permission and I have the building permit, so the city government doesn't have any objection. So what's your problem? So you see, again, what you have here are two conflicting issues. One is that the regulatory authority says yes, you can do the construction, but then the law would stipulate that no, if such a situation would result in the loss of sunshine, and obviously in this case solar panels, they are expensive and it's a bit of an investment, and the whole idea is to be sustainable and green. Although this case is from the 1980s, again an American case. So but again, it sort of outlines the sort of issues that come up over here. Is the right to light a human right? Yeah? Well, I guess it depends on perspective. If you are from Italy or from Portugal or India, well, no, I don't think right to light is very important because you have like too much sunshine. But if you are from Estonia or Finland, then or Sweden or wherever, then of course this would be a very fundamental issue for you. It's a fundamental right because we have to take vitamin D every day, and then cry about the fact that we don't have enough sunshine. Another interesting case is Anthony Stephen Davies versus Richard and Margaret Dennis and others. This is from 2009, from the UK. And this is about London and on the River Thames, and so there was some construction done, and a result of this was that you can go on the balcony and you get a view of the river, and whatever. So the view is important, and now one of the neighbors decides to make an extension which would potentially block the view of the other neighbors. And what would be the view? I don't know, that wheel, London Eye, or whatever, Tower of London or the Bridge of London or whatever, London Bridge. So the issue here is, of course, again very interesting because the regulatory authority says yes, you can make the extension, but then the neighbors say no, you cannot because it affects their rights, and so the right to a view, the right to light, all of these are taken into account, and they are relevant for us because you can see how something like this can potentially have an impact of millions of euros or pounds on property development schemes and ideas that people have. So something to read and hopefully appreciate. So that's over here, of course, and this is something that plays a role. Now that this is over and we have looked at and discussed the law of neighbors with regard to servitudes and easements, So now it would be a good time to look at another issue which deals with the concept of nuisance. And again, a very English concept. The whole idea here is that you should not, basically cause any disturbance to your neighbors. Now, I'm sure all of you have at some point or the other had problems with your neighbors. And I can say this because during the physical classes, when I often talk about such examples, then at the end of the class, there are always one or two students who come and tell me that, yeah, well, actually, we are having a similar real life issue. Either it's in your residential area, or it's in the countryside where you have a country cottage, or whatever. And so these are disputes between neighbors, and of course it's important to look over here at what is the exact definition of a nuisance, and what is the bigger picture or the problem that comes up over here. So in England, you have the law of torts, or you have under Estonian Property Act also nuisances that are laid out, and similarly in the case of French law as well. And so if you were to look, for example, at the Estonian Property Act, yeah, so we have this here Law of Property Act, and I've put up this 143. So let's see here. Yeah. Well, subdivision 2, neighboring rights and damaging nuisances, and what are the issues that arise. So of course it's very important to look at the definition of a nuisance, and it's something which causes hurt, inconvenience, or damages, or which essentially interferes with the enjoyment of life or property. Now, there are, of course, different types of nuisances that come up over here. One issue is when you live in a flat, for example, you try to live a healthy life, a vegan lifestyle, you do yoga, and you do all sorts of nice things. And then you have this crazy neighbor who smokes a cigarette in the bathroom, and then, the cigarette smoke spreads everywhere. Yeah, that's a nuisance. Or you have somebody who has 5 dogs, and this person doesn't believe in the fact that you shouldn't let your dogs do pee pee or whatever all over in the corridor. Yeah, nuisance. Another issue with nuisance could be, well, coming back to Talon, there's this Wabadus Waliak, yeah, the Freedom Square, and next to that, I think, is this yellow church. It's Yani Kirik, I think, yeah. And is it Yani Kirik? It's let's see, there are all these different ones here. Talon, Yani Kirik. Yeah, that's the one, Yani Kirik. All right. And so now Wabadus Walyak, this place was just an open ground, and then the city wanted to make underground parking and all that fancy stuff. So they made this giant hole where the Wabadus Walyak ground is, and so that's where they were doing the construction. And during the construction process, there was a crack on Yani Kirik walls, yeah, and of course that's very upsetting, especially when the church is 300 or 400 years old. So again, issues dealing with nuisances and the problems that can arise in this regard. So of course the most basic rule is use your property so as not to injure others, and that's quite straightforward. But you can have issues with pets, you can have issues with music, you can have issues with conflicts that come up regarding the usage of land, and then there are a lot of examples in this regard. But you have to remember here that one is a nuisance, which could be very minimal in a way, and not really something that should upset you. And then on the other scale, you have something which really causes damage. So a neighbor who smokes in the bathroom, and the ventilation system now distributes the cigarette smoke all around. Well, normally it shouldn't be an issue, but yeah, the fact here is if you have asthma or some other disease, or imbalance or a physical condition, then of course medical condition, then of course this can be an aggravating factor. Another issue could be, for example, let's say you're some old person and you live near a kindergarten, and now of course kindergarten children are noisy and they're running around all the time, and would you be justified in saying that this is a nuisance? So again, you see, this issue gets quite nuanced in several ways. Another issue is, very often now because of the pandemic, let's presume, so you can't live in Helsinki or in Tallinn because it's a life or death situation here. So now you want to live in the countryside, and so let's presume you spend some money and buy a country cottage in a rural area, surrounded by fields and farms and cows and good internet connection and a good road, and so you can live here now until the coronavirus pandemic ends, whatever. So now you move in, and then you realize that your neighbor has horses or cows, and of course, besides looking cute, they are also stinky, and so they start stinking. And so now, is that a nuisance? There's been a cow dairy or a farm for 100 years, and now you come there, buy a house in a country cottage. I mean, in a country cottage nearby, and now you're this new person, and you are saying, hey, this is disturbing me. I don't like the smell of cow shit, so please close down the cow farm. Can you do that? So of course, you see, there are a lot of these questions that come up over here, and a lot of these can be quite problematic because there's a right of one landowner to use her land as she chooses, and then the right of another landowner to be free from interference in the use of his land. And again, this can cause a lot of issues. In Germany, for example, I remember somebody had a house next to a farm, and this person got cancer, and then he sued the farmer and said, the farmer is using all these insecticides and pesticides and chemical stuff, and because of that, this guy who has a neighboring house, he lives there, so he got exposure to all these chemicals, and so now he has cancer. So you see, a lot of these issues that come up with nuisance are quite interesting, and of course they result in a lot of legal disputes. So the owner of an immovable, if you look at section 143 of the Estonian Property Act, does not have the right to prohibit different things unless there's a significant damage to the use of the owner's immovable or is contrary to environmental protection requirements. Now, this is often an issue. I have friends who have restaurants, and they often complain about how they have to deal with neighbors who get very upset because the ventilation system is making a lot of noise, or it's one of those fancy ethnic restaurants, and so they make all this spicy stuff, and now of course the fumes go out, and then neighbors are complaining that they're getting the smell in their homes and houses, and they're not into spicy Indian or whatever Bangkok, Thailand food, Thai food or whatever. So again, you see, a lot of these are issues that come up. So as the law clearly stipulates, it's okay to have a bit of noise, to have a bit of smell, a bit of smoke or whatever, and you can't really prevent your neighbor from doing that unless there is significant damage to the use of the owner's property, immovable property, or it causes problems which are contrary to what the environmental protection requirements stipulate. Especially if you're renting, this often comes up. People have a piano at home, or a child who is learning music, or children running around, or then a child is crying, and then the neighbors get upset, and then they sort of threaten to call the police, or they actually call the police. And this is something that even happened once. I knew this one woman, and she had a single mom, and she had a child, and the child was crying, and then there was this old woman living downstairs or something, and she called the cops, and she said, oh, I think my upstairs neighbor is doing something very bad to her child. Yeah. And then the police came, and then of course the young mother was quite upset about this entire thing. In fact, I think a few months ago in Tallinn, this was that there was a situation, and then the downstairs neighbor was some old grumpy guy, and he came up with a gun and he shot the woman in front of her children. So again, you see a lot of these issues come up, and especially in the times of a pandemic like this, where we are at home, working from home, locked in, and then so you're at home 24/7, with maybe some short breaks where you can go out sometimes, but really not much to do. I mean, the universities are shut, offices are shut, so you're supposed to work from home. And this can be quite problematic, because then you have to deal with neighbors 24/7, and all of these problems that arise in this context. It also stipulates, under section 143 is also stipulated, that if the neighbor cannot be expected to eliminate the nuisance for economic reasons, then the person who's affected can demand compensation. So again, this is an interesting take on what are clearly legal issues. This can also get a bit complicated sometimes. For example, if you are renting a flat, so now you're a tenant, and in that situation, how would you go about taking action against a neighbor? Because the neighbor will say, I don't know who you are, I only deal with the owner of the property. I'm the owner of a flat. I only know the other person who's the owner of the flat. I don't know who you are. You're just a tenant. Or what about people who travel and live in Airbnb and these sort of shared accommodations? So again, a lot of these issues. In fact, well, not anymore nowadays, but I remember when my wife and some friends, they went to London. They were looking at Airbnb, and um, yeah, it's just like they got this flat for 2 days, but when they went there, the house had a board saying that this is not suitable for Airbnb people. But of course, whoever was renting out the flat was doing it anyways. So you have these sort of situations, which now leads us to the fact that we have defined nuisance. Yeah, we have looked at some case studies, some examples, and so you've probably now agree that nuisance can be quite an issue. But now we have to look at things from a legal viewpoint, and the legal question that comes up over here is, what sort of nuisance are we looking at? Is it a private nuisance, or is it a public nuisance? Now, why would this be relevant at all? Well, this is relevant because we have certain issues that can arise in the context of nuisance. So the issue that comes up here is, if it's a private nuisance, it's between you and me, yeah, two people, and so I can sue you in a court of law. But if it's a public nuisance, now it affects 1,000 people. So the question that comes up now is, well, how do you go about filing a representative suit? Who represents 1,000 people? Yeah, you see, that's very important, because now what we're looking at is a legal situation from a purely, procedural point of view, but also from a justice point of view, and this is now your code of civil procedure, or code, or whatever requirements are there. And one key element is that all necessary parties to the suit should be involved in the hearing. Yeah. So I'll give you an example of this, just in a very basic way. Let's say I fail you. Now, out of the box thinking. So you are upset with me because I have failed you as an individual, just you, nobody else. So who would you sue? Well, this is a purely legal question. Of course, you would sue me, but now also the question is, well, I don't own the university or something, I'm an employee. So you would also have to sue Caltech University. All right. So clearly over here we have three parties to the suit. One would be the plaintiff, that's you, and defendant number one would be me. Defendant number two would be the university. Well, that's straightforward. In this lawsuit, can you bring in your grandmother? No, she has nothing to do with you or me giving you a zero. So of course you can't bring in your parents or family and all that. And this is very important, because the essential parties to the suit have to be there. If you just sue me, what's the point? The mark sheets or the grades have to be changed by the dean's office, So of course you have to involve the university. So that would be a private situation, for example. But now let's look at a public situation. I fail all of you. All right, all 50, 100 students that I have, everybody gets failed. Now, as a lawyer, you have to ask certain questions. Number one is, who are the parties to the suit, the necessary parties? And then, of course, there are other questions like, how do you determine jurisdiction, which court of law, is it a civil matter or a criminal matter? Very basic things, but very important things. So in this case, you're a class of 50 students. I fail all of you. Can you alone file a lawsuit against me and the university? Not really, right? Because now this is more of a class issue. The point here is I failed the entire class because I felt that all of you are not doing your work properly. So you see, it's not an individual issue anymore, but now it's a broader issue. And that's the same that comes up over here. When you have a nuisance, is it a private nuisance? Is it a public nuisance? Is it a private and slash or public nuisance? Now this is very, very important, because if this is not taken into account and answered properly, then you have an infructuous suit. Basically, you have failed to take into account all the necessary parties, and because of this your suit can be dismissed. You see, so again, these are issues that come up, and we'll talk about this in more detail in the next lecture, and I'll talk about the different types of nuisances, the different case studies and laws about this, some aspects that come up with regard to these issues. And once that is done, then we just have to look at surface water, and then we are pretty much done with this course. Then I'll probably do some revision lectures on things, and I'm not even sure, maybe have finally an MS Teams get together. Yeah, whoever is interested to ask me something in person. I don't know. Let's see how that goes. Anyways, that's it for today. Let's stop here and leave things for the next time now. So until next time, thank you for your patience. Yeah, and I hope to see you again next week. So goodbye.